So today, the Supreme Court heard an important case that it should not have been here. And it revolves around a conservative Christian web designer in Colorado who wants an exemption to a state law so she doesn't have to design websites for same-sex marriages. And the reason the court shouldn't have been hearing the case is because nothing's actually happened. No injury has occurred because no one has asked her to make a website or forced her to make such a website. It hasn't happened. She just preemptively sued the state of Colorado, arguing that should that happen, her First Amendment rights would be violated. She has a First Amendment right to refuse to make hypothetical websites for hypothetical same-sex couples because of her actual beliefs. And because the conservative majority has tossed away all pretense of being anything other than essentially a high council of Fox News viewers, they decided her case should be heard before the Supreme Court of the United States of America. Very, very few cases get to do that. And so today, they were hearing the case, making the arguments, and sounding more like callers into a right-wing radio show than Supreme Court justices. Just listen to how Samuel Alito responded to a hypothetical situation raised by Justice Ketanji Brown Jackson. Jackson saying, "Can you give me your thoughts on a photography business in a shopping mall during this holiday season that offers a product called Scenes with Santa? And this business wants to express its own view of nostalgia." Jackson continues, "Because they're trying to capture the feelings of a certain era, the policy is that only white children can be photographed with Santa in this way. The objection, just like your client's objection, is to expressions that violate their own views of what is being depicted." Alito, "So if there's a black Santa at the other end of the mall, he doesn't want his picture taken with a child who's dressed up in a Ku Klux Klan outfit, that black Santa has to do that?" The lawyer, "No, because Ku Klux Klan outfits are not protected characteristics under public accommodation laws." Kagan, "And presumably that would be the same Ku Klux Klan outfits, whether the child was black or white or any other characteristic?" If you, viewer, are like, where is this going? Alito, "You see a lot of black children in Ku Klux Klan outfits, right? All the time." There was a lot of laughter in the courtroom at that moment, although very confusing. Then there was Justice Neil Gorsuch raising the case of a Colorado baker who refused to make a cake for a same-sex couple and was told to undergo non-discrimination compliance training.
Mr. Phillips did go through a re-education training program pursuant to Colorado law, did he not, Mr. Olson?
He went through a process that ensured he was familiar with...
It was a re-education program, right?
It was not a re-education program.
What do you call it?
It was a process to make sure he was familiar with Colorado law.
Someone might be excused for calling that a re-education
I strongly
program.
disagree, Justice Gorsuch.
Thank you, Mr. Olson.
Re-education program, of course, is a reference to Maoist camps during the Cultural Revolution. The arguments lasted for 2.5 hours. It seemed pretty clear which way the conservative majority will eventually rule. I'm joined now by Melissa Murray, professor at New York University School of Law, co-host, along with Leah Lippman and my wife, Kate Shaw, of the Strict Scrutiny podcast, and Ellie Mistel, the justice correspondent for The Nation. And it is great to have you both here in person. So I want to just start with this initial point, and I should say that Kate made this point to me when she was giving me her own tailored preview for me about the case a few weeks ago, and I just couldn't believe that it was true, which is that the plaintiff has sustained no injury, right? I'm not missing this. No one made her make a website, right? There's no dispute between two parties like that's happened. This is purely a hypothetical about the future.
Purely hypothetical, purely speculative, purely theoretical. And it's the reason why you had all of these completely outlandish, kind of offensive hypotheticals from Justice Alito and company. I mean, the black children in KKK costumes. None of this would be happening if we actually had facts on the record that could be discussed in this case.
Right. And so instead, you've got this very weird, almost kind of law school riff session in the arguments today that were really strange and very long.
Yes, but there was a point to them, right? And what they were trying to do is completely misunderstand the nature of rights in this country, right? So the right wing really loved to go to these racial analogies, to go to these KK analogies, trying to suggest that anybody who is against same-sex marriage is like the KKK to a black person, right? So like that was the kind of Samuel Alito being a 4chan troll. That was the kind of thing that he was trying to do, but they fundamentally misunderstood the law, right? Because here's the deal, Chris. One of the ones they used was the black carpenter who makes crosses but doesn't want to make a cross for the KKK.
Right.
Isn't that discrimination? No, it's not discrimination, because if I'm a black carpenter, I can easily say I don't want to make crosses for the KKK. What I can't do is say I don't want to make crosses for. What I can't say is I will not make any crosses for white folks.
Yes.
Now it is Sam Alito and Amy Barrett who seems to think that there is no difference between white folks and the KKK. I happen to think better of white people and think that there's a huge difference between a white person who wants a cross for a religious ceremony and a white person who wants a cross for a Klan rally.
So this is where we kept coming back to, which is the case, and in case people aren't tracking here, right? We've had the Masterpiece
Cakeshop.
Masterpiece Cakeshop. That is the Christian bakers who don't want to bake a wedding cake for a gay couple, right? That is a religious protection, right? So we want to carve out from these sort of generally applicable non-discrimination laws that if you have a religious objection. So that's Masterpiece Cakeshop. This is not that, right? This is under the First Amendment saying you can't compel me to make speech I don't disagree with.
Well, so let's first be clear. When Lori Smith, who is the plaintiff in this case, brought her suit, she did have a religious liberty claim. She was essentially arguing that it violated her rights to free exercise of religion to be compelled to serve same-sex couples by providing websites. But
even though no one is masturbating,
even though she hasn't served anyone, served anyone, the theoretical gay couples. But she also has this compelled speech claim. When the court granted certiorari on this case, they only granted it as to one issue, the compelled speech issue. Why they didn't touch the religious question, up for grabs. Maybe it's because they've done so much to expand the scope of free exercise over the last couple of years. Maybe it's because there are individuals raising free exercise claims in response to limitations on reproductive rights. Who knows? But maybe it's also because this case was literally created in a lab to bring this question to the Supreme Court. And so it's a compelled speech case. She's arguing that Colorado is making her say that she endorses same-sex marriages, which she does not because of her religious views. But what's missing in all of this, while we're talking about Lori Smith, while we're talking about the prospective speculative injuries she may or may not suffer, is we're not talking about the actual same-sex couples who are going to be denied equal treatment in the marketplace. And that's the thing that really was lost in this entire argument. She was the victim. The other victims of discrimination were completely absent from this.
It's because the case was already determined before the judges heard a single argument.
Right.
The real issue is, and there's a scintilla of a point here, right? Obviously, the government cannot compel you to say anything, right?
Right. You can't say everyone in Colorado has to write an op-ed saying they like same-sex marriage. Clearly not.
Government clearly can't compel you. Can't. So what Lori is trying to say, what the website designer is trying to say, is that she has a content-based reason to discriminate against the messages that she's willing to do, and she is right to have that content-based discrimination. However, what she's doing is going for status-based discrimination. So she's trying to say that gay people can't come into my store.
Right.
Not that because as we all have been saying, no gay person is asking her to do anything, right? But she's trying to say that gay people can't even come into your store, and that's something that takes us right back to the Jim Crow era. Well, because it used to be that the racist lunch counter people were just like, I have a religious objection to black people at my store. You can't say that. We've moved beyond that. People like Sam Alito are trying to take us back there.
It seems to me that you've got this weird perverse thing happening in the court, if I can sort of step back, when you look at the First Amendment, which is we think about the First Amendment sort of protecting rights. And obviously it protects rights in a complicated way because some rights are in tension within the umbrella of the First Amendment. But going back to, say, Citizens United, right, which is a First Amendment case, this sort of use of the First Amendment as this kind of weapon for the dominant group versus the marginalized group, for the powerful rich millionaires versus the voters and public interest, where all of a sudden this thing looks like it's being used by this particular majority on behalf of folks who already have a kind of disproportionate power.
Let me put it in context. A couple of weeks ago, we were talking about the affirmative action cases that the court was hearing, and that was a case that was sort of brought under the question of the Equal Protection Clause, this part of the Constitution created to bring formerly enslaved individuals into the body politic as citizens. What we are seeing from this court is a refusal to use the Equal Protection Clause to redress racial injuries unless they happen to white people. Whereas we are perfectly happy to expand the First Amendment for the purpose of remedying these imagined injuries, expand the Second Amendment to remedy these imagined injuries, but we won't do it in this way that was actually intended by the framers of the Constitution.
There also just seems to me, I mean, the Gorsuch line there with the re-education camp. I mean, look, it's true. Scalia was never pretending where he was coming from in cases. I mean, famously, right? Like, you sort of knew where he was coming from, and he was quite sort of like forthrightly ideological and pressing the people. But it just I was just so struck by that moment where it's like, you're giving away the whole game when you're trying to like bully the lawyer into calling compliance training re-education camps or re-education classes. What even are we doing? Like, you've given up the pretense that you're doing any judging. You're like, we know where you're going to end up.
Yeah, they're all in the same bubble. They're all in the same right-wing echo chamber where they all talk to each other and they think that things that aren't real are real. It's not all that different than what we see happening with Republicans in Congress, right?
That's a good point.
They're all...
Or at the state legislatures. I mean, this is the same kind of line against CRT being taught in elementary schools, which never actually happens.
Camps, right.
Yeah,
and from my perspective, there's almost a good thing here, because for too long the Supreme Court justices have hidden behind a veil of secrecy and a lack of transparency, where people think that they are impartial arbiters.
Balls and strikes, right?
And what's happening right now is they are showing you just how desperately partisan they are, and they're willing to make themselves sound like fools to do it.
Yeah, and the neutrality robes that they don, which are literal cloaks to like costume themselves as neutral arbiters of the law, like can't mask what we're hearing when they're talking about re-education camps. Melissa Murray, Ellie Mistal, great to have you both here.
Woman at the heart of this case. She's the owner and founder of 303 Creative and is joined by her attorney, Kristen Waggoner. Welcome to both of you. Good to have you here. Lori, the argument that's being made by the other side is that when you offer services, you have to offer them to all, to everyone. You heard what the ACLU attorney there was saying. Tell me what that violates for you, Lori.
I want to create unique, one-of-a-kind expression and artwork, and I want to design websites, wedding websites specifically, that are consistent with my faith. But the state of Colorado is compelling and controlling my speech, chilling it, and forcing me to communicate a message through my custom, unique artwork. That violates the core of who I am. And at the core of this case is the right for all to speak freely. And that protects not only myself, protects the LGBT web designer who should not be forced to create custom artwork that opposes same-sex marriage. The right to speak freely is guaranteed to each and every one of us, and a win for me is a win for everybody.
So, Kristen, along the way in this case, there was an argument that was made that because her content is unique, she is creating sort of a monopoly, and she's not allowing this person who wants to have a same-sex marriage website access to that monopoly. What do you say to that element of this case, to that argument?
Well, that would turn the First Amendment on its head. That would mean that every single one of us can be forced to express the government's message. What's important here is that Colorado even agrees that Ms. Smith serves all people. She does serve everyone. She has clients who identify as LGBT, and she serves them. And as the court many times today mentioned, her decisions turn on what the message is and not who the person is. And we all want that freedom, whether we're a Democrat publicist and don't want to write for a Republican, or a pro-abortion photographer and don't want to have to film or photograph a pro-life rally.
So, Lori, you're saying that you serve people of all different sexual preferences, just not when it comes to a wedding website?
I serve people from all different walks of life, and I do have clients who identify as LGBT. I cannot create every message requested of me. There are some messages I can't create no matter who requests them. And at the core of this case is the right for everyone to speak consistent with what they believe, whether their views on marriage or other topics are similar to mine or perhaps different. No one should be punished for communicating and speaking and creating custom artwork that goes along lines with what they believe.
So, Kristen, based on the questions and the back and forth from the justices, what's your take on where they are on this right now?
Well, the court has never compelled someone to create messages, meaning using their heart, their head, and their hand to imagine and design art and use words and text. The court has never compelled that kind of speech. Even at the height of the civil rights era, it didn't compel speech, because that's not the role of the government, to tell Americans what's worthy of celebration. And as you introed with the ACLU's message, it's disingenuous to suggest that this is about service. It's about speech.
Well, they're saying that you could also ban Jewish people or black people from receiving this service, Kristen.
That's not at all true. You can't, under public accommodation laws, deny an entire class of people service. And again, the courts are going to recognize that. Nothing about this decision changes that. But it's also true that it's not the role of the government to mandate what is true and what's not. That's the role of the citizen, to be able to decide what to express. No one should be forced to express a message that violates their convictions. And in Colorado, they are doing it upon threat of fines. Some jurisdictions impose jail time.
Kristen Waggoner and Lori Smith will be watching the case. Thank you very much. Good to have you both here today.